Thank you, David, for actually being here at all. David, as I think I mentioned before, this morning was meeting with the governor of Puerto Rico, who does, I think, take precedence over an academic symposium, and it would have been perfectly ordinary and legitimate for you to have said, I can't come at all. So,
I appreciate it, yeah. Ted. And it relates to what we're talking about in all sorts of different ways, so it's a seamless web. So I just had four kind of stray comments on the kinds of things that we're talking about. One is with respect to the creditors acting badly and the empty voting kinds of issues. My reaction to that is always to ask the question, how big a problem really is it? Is this really warping bankruptcy cases? Or is it a manageable problem or not a huge problem that we're taking out elephant guns, at least on occasion, in some of the things that we're proposing? And it does seem to me it's an issue, and the change in the nature of creditors is a real issue and creates stresses in bankruptcy. But it's not obvious to me it requires radical change to bankruptcy. So when I think about the empty creditor kind of set of issues, it seems to me that if you invigorated 1126E a little bit, if judges were a little bit more willing to disqualify votes when there looks like there's a problem than they have been in recent decades, I think that could help. I also do like the idea of more disclosure in this context. I think only requiring ad hoc committees to disclose, I mean, it's a step forward, but there really ought to be disclosure by any major player of what their true economic interest is. So that was my first thought. The second is, with respect to fiduciary duty, when people talk about fiduciary duty as a solution to some of these problems, and this was what John was talking about, and I was pretty prepared when I started reading his article to disagree with him. I've disagreed with almost all the law professors at this table in print, and almost all of them have disagreed with me. It's what we do for a living. But I actually found myself pretty much in agreement. I am a big skeptic of expanding fiduciary duty as a way to solve these kinds of problems. So suddenly to discover that creditors' committees have these complicated fiduciary duties, or the debtor in possession has complicated fiduciary duties. I kind of like the tenor of the discussion of you do the best you can in an awkward situation. And it strikes me that if there ever were a serious move to magnify the fiduciary duties and to add teeth to them in the bankruptcy context, it would be quite ironic because things are going exactly in the opposite direction in corporate law. Delaware is trying to figure out ways to proceduralize fiduciary duties to rein them in, to keep them from expanding. And one might have mixed views about that and what Delaware is doing, but I don't see fiduciary duty as a solution in bankruptcy. And I think I like what I take to be Jay's point, that the judge can fill in. The bankruptcy judge has a role to fill in some of those gaps, and I wouldn't want to put more pressure on them either, but bankruptcy is different than outside of bankruptcy. The third of my four thoughts is if you are going to change things, or at least tinker a little bit legislatively, not just in terms of how we think about, and in theory judges might apply the rules. One thing I think would be worth thinking about is the voting requirements. It is really easy to have a hold-up position in a class. I think it's worth thinking about, would a simple majority voting requirement be better than a two-thirds voting requirement to reduce the risk of hold-up? Another issue that I'll just throw out there, I don't have a settled opinion on it, but it's a big issue, and I know former Judge Peck has written about this when he was wearing robes, and that is the impaired class requirement, and how do you think about that in a complicated corporate structure? I think it's a really hard question. I think the impaired class requirement is important. I'm not with those that think we should get rid of it. But what you do with it when you have a fragmented corporate enterprise is a really tricky issue, it seems to me. Is that safe? I didn't, now I can criticize you if I wanted to, but.
You could have criticized me then, too.
Oh, did I? Oh, good. I thought it wasn't, but that's even better when you criticize without, I said it's a hard question.
Agnostic criticism.
Well, I note that one of the articles that's written about your opinion, they were against you before they were for you. So some academics have switched sides, have seen the light of your opinion, at least one of them. The last thing that I wanted to throw out is we've talked a fair amount about creditors behaving badly or not behaving badly, and one of the areas where it's really hard to tell when they're behaving badly and when they're behaving well, that hasn't come up, at least in the conversation I've heard, is intercreditor agreements and restructuring support agreements. They're at the heart of a lot of the big cases right now. It strikes me that courts are really struggling to figure out what to do with them and how to determine when they're problematic, when they're good. I'll just throw out one thought about them. My sense of the emerging case law is that it tends to be pretty skeptical of intercreditor agreements. What seems to be the emerging standard is that they will not be followed unless they are clear beyond peradventure, is the language in the opinions. Whereas with restructuring support agreements, there seems to be a great sympathy for them. I think because they are after the fact rather than before the fact, they're entered into at a time when the parties have more information rather than less information. But it seems to me that the approach to them may be a little bit backwards, or at least the way that the decisions are pointing. It seems to me that courts have been a little too skeptical of intercreditor agreements, and maybe not quite as skeptical as they ought to be of restructuring support agreements. And with restructuring support agreements in particular, the thing I worry about, this is something that Douglas Baird has mentioned in an article on this, is it has the effect of silencing creditors. So once a creditor signs up for an RSA, they are no longer a voice, and to the extent that voice might be protecting not just themselves but other people, you're losing an important input into the process. So I'll stop with that.
That's their point. That's their point, these agreements.
Oh, absolutely. Oh, absolutely.
Jim?
Considering that David was going to be on a different panel, he fits in perfectly here.
He's good that way.
I have
Usually I fit in best on the panel that I'm not on.
I have some miscellaneous observations to make. A number of them are based upon anecdotal experience. So consider this a collection of anecdotes that generally tied to the umbrella of this symposium, but may not have that much in common with one another. The test will be if you can connect the dots that I'm about to throw out. Dot number one. One of the things we haven't talked about at all today is exclusivity as a means to maintain control within a Chapter 11 case. It's a surprising omission. It's just something that as I was thinking about the day, should have been mentioned, so I'm mentioning it now. It is a means to opening up the process for change of control transactions within Chapter 11, and those who think they have set the table properly at the beginning of the case may discover later in the case that they've lost control. My next observation goes to the general title of this section of the symposium, which is reform necessary? I'll answer it, no. I don't think it is. I say that notwithstanding the fact that Don was here this morning talking about some of his work through the ABI Commission on Bankruptcy Reform, notwithstanding the fact that I spent some time working on one of their advisory committees, along with Stephen, notwithstanding the fact that the law probably needs a refresh, but I don't know if it needs a refresh in the area that we're describing. And one of the reasons I'm going to suggest that is my own empirical experience, and here are those examples. And you don't necessarily take much away from these examples, but I'm going to start with the most recent one. I was an estate fiduciary for about a week in a case called Woodbridge. Bob Gerber, who was here, and I'm sorry he left because I would have enjoyed hearing what he would say as one of the three managers of this very troubled business. But we were picked, along with Jan Baker, to provide interim management from the inside of a company that we had no connection to. It is the first time in my long career that instead of being an advisor to a fiduciary, I was the fiduciary. It is different. The noose around your neck does concentrate the mind. And there is, no matter what we say about fiduciary duties and their role in Chapter 11, I think a useful channeling of positive thinking on the part of true independent fiduciaries to do the right thing for the right reasons. In that particular case, and without going into the details of it too deeply, the SEC brought claims against the then person in control, an individual named Robert Shapiro. Robert Shapiro, in December, transferred control of his empire, which might have been a Ponzi scheme, I make no comments about that, to another independent party, truly independent, who ran the case for a while, started the bankruptcy, and shortly after he started the case, he confronted a motion for appointment of a Chapter 11 trustee. One of the things that we decided as members of this board of managers, with the advice of counsel, and spending, I might tell you, an awful lot of time thinking about the issue, was what our duty was to deal with the motion for appointment of a Chapter 11 trustee. And one of the things that we discerned was that, as is the case in many motions brought in bankruptcy court, the parties bringing the motion actually didn't want the relief. What they wanted was a change in governance. We became the means to that end. That experience suggests to me that the standard practices in Chapter 11 under the Bankruptcy Code for replacing management are actually often a means to a different end. In this instance, it was an independent board. We flipped our management to truly independents that were picked by stakeholders. We were picked by somebody who wasn't a true stakeholder. At the hearing that took place before Judge Carey, the lawyer representing the Creditors Committee, Richard Pacholsky, said, the board that was there wouldn't have mattered if they were Moses, Jesus Christ, and Mother Teresa. We would still want them replaced. So Judge Gerber, Jan Baker, and I stepped aside. The parties who came in, and I think this is an important insight, all had loyalties to particular stakes or groups in the capital structure. One was a selection from the SEC, one was a selection from the Creditors Committee, one was a selection that we made. What I'm suggesting is that it's not just whether there are independents within the board, but whether they're perceived to represent constituencies within the case so that they can be, if not manipulated, at least relied upon to do the right thing. Two more examples, and then I'll stop. One is American Airlines. I was the mediator for labor issues in the American Airlines case. In that case, the three unions were all extremely hostile to management. Management was in control of the company, put the company into bankruptcy with, I think, over $5 billion, $6 billion in the bank. There was no need for DIP financing. It was a company that may have needed a little bit of an operational fix when it came to dealing with unions, dealing with leases, dealing with some of their routes. But their premise was, this is going to be a standalone bankruptcy. During the negotiations with each of the unions, pilots, flight attendants, and mechanics, I discovered enormous hostility to the management of the company, enormous skepticism to the adequacy of the business plan, and enormous acceptance of the notion that the airline needed to be acquired. And they were easy pickings for U.S. Airways that came in through the back door to the unions, made a proposal regarding how their contracts might be reset. And the unions became the control party in a change of control transaction within a Chapter 11 case. I mention it because I think it's both exceptional and proves the point that not everything we're talking about here plays well in reality. Reality is different. Last point, or last anecdote. A case we worked on, and I worked on it very closely, called Maxis Energy, is a reference point for an article that I wrote with some of my colleagues that appeared in the January edition of the American Bankruptcy Institute Journal. The title of the article, which I happen to love, is The Importance of Being Truly Independent. Think of the importance of being earnest. And the reason for the article and the reason for talking about it now is that I had vivid, direct experience with something that I considered extraordinary. We were hired to represent a special committee, pre-bankruptcy, that had been appointed by the board of this company, Maxis Energy. Maxis, in turn, was an indirect subsidiary of YPF, one of the largest petroleum companies in South America, and in fact a state-owned enterprise in Argentina. The job that we had pre-bankruptcy was to act in a very isolated way with the independent directors and to investigate alter ego liability claims that might be made against the parent in connection with approximately $12 billion of environmental exposure that the company had, that another party, Occidental Petroleum, was saying YPF or another company, Repsol, actually should be exposed to under principles of piercing the corporate veil or alter ego. We did the investigation, did the report, entered into settlement negotiations with YPF pre-bankruptcy, settled the claims for $130 million, filed the case, and used the settlement agreement as the basis for the reorganization proposition within the bankruptcy. The creditors hated it. And during their very actively expressed disregard for what we had accomplished, they raised a series of objections to corporate governance. And their concern within the bankruptcy was that it was a 5-person board. 3 members of the board were associated with and had been appointed by YPF. 2 members of the board were the special committee. The concern was, should there be a trustee? Should there be new bylaws to give the independent directors full and complete authority for for what goes on within the bankruptcy. We negotiated a set of new bylaws over a period of maybe 4 months. It was a very, very difficult negotiation, finally resolved. And then the interesting thing that happened was at the end of the case, just before a plan was ultimately put together, the creditors committee came to the independent directors and they said, in substance, we, the creditors, own you. You have a duty to do what's best for us. What's best for us, in our opinion, and we took another look at that investigation that was done pre-bankruptcy, what's best for us is to trash that $130 million settlement and pursue claims post-confirmation against Occidental Chemical. Occidental was the party pursuing the claims, against YPF for alter ego liability. So much money was at stake it couldn't be settled. The independent directors attorned to the creditors committee. So in the conversation we had last night at the Zaretsky about duties owed, in the circumstances of a hopelessly insolvent entity, which is what this was, it was exposed to multiple billions of dollars in claims and was totally dependent on advances from its parent. The board, through the independents, recognized a duty owed to creditors, only creditors. I have more I could say, but I think I'll stop.
Yeah, so I, too, am going to sort of talk a little bit from experience and anecdotes without necessarily mentioning cases. And I share, I will never stop calling you Judge Peck. I share Judge Peck's basic view that I don't think there are, in the main, legislative or other reforms that are needed. I worry that you do more harm than good, but I do think there needs to be vigilance in areas. Let me start with a place that Judge Peck touched on, and I was going to touch on exclusivity. The debtor in possession in a Chapter 11 case comes in a position of great strength and leverage, frankly. It is the debtor in possession. It has exclusivity. It comes, I think, appropriately with a presumption. I would imagine almost every bankruptcy judge feels this way, that in the absence of evidence to the contrary, the walking-in presumption is that the debtor in possession is going to be a fiduciary and do the right thing. It does seem to me that when you see cases with a pre-petition RSA, like Seadrill, like Peabody, where a subset of creditors in the same class is getting different treatment. It's always, the argument always is, you're not getting better treatment in respect to your claims. You, the 70% of this class, you're getting it because you're putting in fresh money. I still think judges need to ask the question, is there a quid pro quo, and is that quid pro quo illegitimate? Is, when you look at the deal, management getting releases? Is, if the underlying equity holders are private equity firms, are they getting releases from fraudulent transfer or other liability? And is management getting management incentive plans that are too rich? I don't propose a legislative solution, but I do think that when you see cases like that, your antenna, it's not a red flag, but it's a pink flag. It's a look at it hard and figure out whether fundamentally a subset of creditors are getting a better deal. And I guess for Mr. Skeel, the flip side is saying, should we only require 51% in dollar amount of creditors to have an accepting class, is the ability to get control of a case and say, give me a better deal than the other guys, becomes that much easier. I don't have to buy 66.67% of the class. I only have to buy 50.1% of the class. Second point, one thing we haven't talked a lot about today, I think at all really, except maybe in the Nortel example, is cases with affiliated debtors. That's the real world of at least big cases. When Nortel files, there isn't just one Nortel. It is a shame Judge Gerber isn't here because a case that he gave a lot of sweat and blood to was Adelphia. Adelphia was hundreds, I think, when you got done with all the cable companies. And you need to understand what's going on in a case like that. The assets are sold at the beginning. This isn't about a reorganization. It is at its core a fight between different ad hoc groups of creditors at different debtors. And they legitimately, you're not going to have subcon. Adelphia was an acquisition. It acquired this cable company, that cable company, the next cable company. Everyone had their own note holders and their own bonds. And then there were a whole bunch of intercompany transactions and services. And depending upon how you divided it up, and you said these intercompany liabilities are legit, these aren't. There is fraudulent transfer liability here on an intercompany basis, there isn't, could make the difference for one group of ad hoc note holders from pennies on the dollar to par plus accrued. So in a case like that, there's the first question. I'm sorry, you're the debtor in possession. How exactly are you going to act as a fiduciary in a dispute between one subsidiary's creditors and the other subsidiary's creditors, to both of whom you owe fiduciary duties? How can you advocate? And frankly, what the debtor in possession and its professionals in that case, Wilkie Farr, did was to recognize that they were inherently conflicted. And so too, frankly, there's one creditors committee. And so one solution would be to say, no, we need to have not one debtor in possession, but 20 debtors in possession. And you can imagine the administrative cost burden that will go up and the administrative burden. What really happened in that case, and I think it's appropriate, and it's apropos of, I forget who made the comment, is each of the different groups of significant creditors with significant economics formed an ad hoc committee and got their own counsel and their own FAs. And when it came to litigating and fighting the battle between the estates, they took the lead, and it became an adversarial system with negotiations. And our legal system is premised on the notion that an adversarial system where people have real money at stake and they're pushing produces the best outcome. So again, I don't think that's a problem, but I think it is the reality that often a single debtor in possession, in my experience, in lots of cases gets conflicted. And I'll just say one footnote on this point and the first point as well. I have been in cases, Energy 21, an oil and gas company, comes to mind, where a debtor is thinking of doing something, recognizes it needs to file, wants to negotiate a deal with its secured creditors, but it recognizes it's got different subsidiaries with different ad hoc, and maybe management's going to get something like a good MIP, and maybe we're going to try to not give these folks here very much. So what do? Well, I know I'm conflicted, so how about 6 weeks before bankruptcy, we appoint an independent director for each of the different debtors that have their own creditors, and we'll let them take a look, and they'll be part of the negotiation, and hopefully they'll bless a deal. I am not going to argue that that is an inappropriate process, but when that person is brought in 6 weeks, 4 weeks before the deal gets done, when it turns out in discovery that they had one meeting before they bless the deal, you create a record that a good, and boy, bankruptcy judges are overwhelmingly good and hardworking, a good judge is going to look at with skepticism, and you should look at that with skepticism. If I want to be in the business of being an independent director and get selected, I'll be cynical here. How do you get that job? You get that job, and I don't mean this in Judge Peck's Woodbridge case, which was truly independent. You get the job in the case I'm suggesting by being someone who management and its advisors, who are law firms and FAs who do this for a living, believe will have the right veneer But I'll be cynical. At the end of the day, we'll go along with management, because if you become too difficult, you don't get hired for the next job.
If I could just break in, I was involved in a case where they were looking for directors, and the casting call was, "We don't want any deep thinkers."
So I do not advocate a rule. If you appoint an independent director within X period before it is per se or presumptively wrong. I just think you have to look at those situations with a degree of healthy skepticism. And in my experience, good judges do, and there's a heck of a lot of good judges. Let me draw raise a different part of Woodbridge, a case that we're certainly around as well. And that is, what is the appropriate role in a bankruptcy process which is intended at its core to maximize value for constituents based on their relative rights, secured creditors, unsecured creditors, equity? What is the role of a regulator? As Judge Peck indicated, the SEC drove that case to some degree by first filing basically bringing litigation pre-petition, suggesting that this company had been potentially a Ponzi scheme, and certainly selling securities without registering any of them. And the company goes into bankruptcy, purportedly hires a new company, new management, new board. Shapiro supposedly goes to the sideline, but he has some potential ability to control or replace. New counsel's brought in, a distinguished law firm, and the SEC says, excuse me, we don't really think these guys are independent. We're going to file a motion for a Chapter 11 trustee in the bankruptcy, but B, we don't think there's an exception to the automatic stay for police powers. We think that that exception applies, and we're filing a motion in federal district court for the appointment of a receiver. And I wonder about whether in cases like that, what is driving the regulator is its desire to enforce the securities laws and punish wrongdoers rather than maximizing creditor recovery, and whether that is a problem. People talked earlier about the WAMU decision, which about the MNPI part of that, but there's another part of WAMU. WAMU, as some of you may know, bank holding companies can go into bankruptcy, but banks cannot. They have to have a receiver. Well, I had the pleasure in WAMU of representing the bank bonds. And my first reaction when I got into the case was, this is great. We're structurally senior to the holding company. We're going to get everything. Well, our fiduciary was the Federal Deposit Insurance Corporation. The fiduciary of the holding company was Weil Gottschall and some other people who do think their fiduciary duty is to maximize creditor recovery. And I think the history of that case and other cases is that structurally junior creditors at the holding company often do better than structurally senior creditors. Maybe that's perfectly appropriate, because creditor maximization and recovery isn't the be-all and end-all, and we should allow independent policy like the SEC, like the FDIC banking policy and securities policy to govern, but it changes the dynamic. Just a couple of other things. One, I do think, and again, I don't favor a difference in rule, but I've certainly been in cases, I'm sure we all have been, where a dominant creditor in one class buys up a blocking position in a different class, paying way above market, solely so it can block in this second class so that it can end up with a plan that favors it in the other class where its real economics are. Obviously, that only works if the bigger, the much bigger class where you already are the 60,000-pound gorilla has more dollars at stake, so to buy the blocking position in the smaller class isn't a problem. By and large, courts have said that is not a ground to designate your vote in either class, but it does create a funny dynamic. And again, I think the only practical solution is not to change the rules, but to have judges, as we have, who are vigilant and to have an adversarial process that allows for real advocacy and disclosure. One final point, and this may not be a governance issue, but it sort of goes maybe a little bit to governance and the multiple debtors. I've been in a few cases where your OPCO, and that's where my clients are, creditors, is solvent. And the debtor is trying to use something in bankruptcy, one of the disallowance provisions in the bankruptcy code on creditor claims, unmatured interest, perfect example, to disallow claims at the OPCO level that would plainly be allowed under state law, so that value can flow up to the holdco and benefit the holdco creditors where the holdco is insolvent. That raises Adelphia, one of the other parts of Adelphia. At the end of the day, the OPCOs ended up solvent. The holdco ended up insolvent. There were potentially $3 billion in pre-petition unsecured, $6 billion in pre-petition fraudulent transfers at the OPCO. Is it appropriate to allow creditors of the holdco to bring fraudulent transfer claims when the actual creditors of the OPCO had been paid in full? The Second Circuit ultimately said, no, it is not. But I've certainly been in cases where a debtor in possession, where there's a solvent OPCO, tries to use the benefits of bankruptcy law, including provisions like the rule against unmatured interest, to benefit the shareholders' creditors. Maybe because I've been an advocate, for some reason, always on the side of the OPCO creditors, that offends me. But again, it's not, to me, I don't think there should be a governance solution, although I am thinking about, and have said I will write an article for the ABI on whether we should amend the code to basically have sort of solvency carve-outs for a whole bunch of provisions. And I think that's something to think about. And it is you may think it never arises. Solvent OPCOs, in my experience, arise more often than you would think they do.
Thank you. To tie it all together.
Well, let me start by saying I've been on the bench about a little over 11 years. And if the goal of Chapter 11 is, in theory, a successful reorganization and maximizing value, I've presided over total failure, almost total failure. The biggest cases I've had in the 11 years, MF Global, ResCap, Borders, 1031 Tax Group, Metaldyne, the list goes on, all wound up either liquidating or 363 sales. And the 363 sales were frequently sooner rather than later. And then the fights began with how whatever they did recover was going to get divvied up. And we talked about that today. You know, I could probably count on one hand the number of successful Chapter 11 reorganized debtors. Alfredo Perez from Weil Gotshal in Houston handled one of those in front of me, probably 8 years ago. And I remember, you know, he was back in front of me maybe 3 or 4 years ago. He's up in New York sometimes. And he says, I got to tell you, the company's doing fabulously. It was a successful reorganization. It was also completely smooth. There were no real fights. Okay, it had a business that had potential for success, and it achieved success. And there were no fights with the creditors. They were able to get everything resolved. So when I look at, you know, the title of this, Market for Corporate Control in the Zone of Insolvency, a lot of it, from my standpoint, does revolve around 363 sales. And sometimes those generates fights initially, whether the sale, what are the bidding procedures, is the buyer really independent or not independent, is management going to continue so that they have the incentive to favor one deal over another deal. I put those in the category of bad conduct by existing management, and I think independent directors go a long way to helping that problem. We talked today about bad conduct by creditors. So from the standpoint of the court, when I think about 363 sales, what ought to be the virtue of it is there's a court who has to approve the transaction. But it depends on disclosure. We really need to know the facts. And I don't think we necessarily do. So we've talked about 2019 today. It's a rule that deals with groups, not individual creditors. Doesn't require disclosure by individual creditors. And what it requires, certainly, I went back and I looked at Bob Gerber's letter to the Rules Advisory Committee from June 2009. He identified all the issues that Ted and Adam talk about in their paper. Bob Gerber, and he didn't, there wasn't original then in 2009.
No, 'cause
he talked
Henry
about
already-
cases that he had going back many years with those problems. Okay, so those problems have existed for a long time. And I think, Ted, some of the things that you recommend would require an amendment to the statute. I think you could forget about that. The chances of that occurring in our lifetimes is probably pretty remote. Some of the things might be dealt with amendments to the Federal Rules of Bankruptcy Procedure. Tough. Okay. The fight over 2019 went on for many years. It was in 2011 when the amendments were finally adopted. The fight was well before Judge Gerber's letter in 2009. That's actually pretty fast. Okay. But if you're going to require disclosure by individual creditors, there's going to be a giant drag-down fight. There was over the groups. What information will be disclosed? They don't have to disclose prices, okay? But you can sort of figure out, people smarter than me can sort of figure out from the tea leaves what's their upside in it, what's their real game. So the empty creditor problem, in some cases, it's enormous. The number, I shared with Ted from a program I did several years ago, a Valcon conference. Somebody at NERA put together a chart. In one of the cases, CDS, the notional value of CDS was $25 billion with $2 billion of debt. Okay, and that was sort of the extreme, but the others were also.
I've seen the chart. Every one of those things, the market was notionally short the company.
Yeah. So, the empty creditor problem. Yes, it's a problem. I think in 11 years, I've had one time when the debtor made a motion to compel disclosure by a creditor about what its net position was. Okay, it wasn't part of a group. Okay, so it didn't have a 2019 disclosure obligation. I wound up not having to decide it. They got it worked out. Okay, but they threw down the gauntlet on that issue. So, I think judges that I know are certainly prepared to deal with the bad creditor conduct issue. You raised some issues in your piece, which I view more of as a thought piece. I agree with the problem. I agree with the problem. It's the solutions that I'm not so sure about. I think as much as I'll speak for myself, Jim can speak for himself, and Bob's been very vocal about it, and Bob Gerber was very vocal in the past. Claims traders are a thorn in our side, but they have provided liquidity to creditors. In MF Global, when that case started, there was $1.6 billion in customer funds that had evaporated essentially overnight. In 5 days, not stolen by anybody, 1.6 billion evaporated. So claims for those customers were trading at 10 cents, 15 cents. The case went on. 25 cents, 50 cents, it wound up 100 cents, but it wasn't the same people. But, was that good, bad? So look, the early cases on claims trading were very paternalistic. They didn't think claims trading should be allowed. Claims trading provides liquidity, okay? And there are creditors, there are people who are involuntary creditors, and they just want out, okay? And so that's the good side. I don't agree. I have, with your premise that control premium is an estate asset, I don't think so. And you haven't, well, let me put it this way. You didn't persuade me that it is. That's a premise of your, of all of your remedies.
Let me let me interrupt on that one. That one was one where we wrote the article, and then my co-author said, what about this? And I said, that's so clearly wrong.
I think it's worth you got it out there.
Well, and then that's the fun. Then I thought about it, and I thought about it, and I thought about it, and I went, oh wait, if I take this argument that Melissa and I are making in a different piece and match it up, not sure, to be perfectly honest, that as a cost benefit, it's what you want to do level, there is a coherent argument for the position. Now, again, I did want to get it out there, because once I thought of it, it wouldn't go away, right? It was like, and so much of what we're putting out there in this piece, some of it is this ought to be part of the toolkit. Some of it is it's part of the toolkit that should be used a little bit more, and some of it is, think about this contradiction and see where it fits in. And
I didn't mean for you to be
No.
defensive about it.
No, that's what I was going to say. I sound defensive. I'm not defensive, only in the sense that I'm not feeling that I wouldn't want you to think that there wasn't, that I didn't want value the disagreement.
Okay. So I think, look, in terms of what are the remedies available today, limited, all right? DBSD, designation of votes, maybe it ought to be more robust. I think there's opportunity in if the right facts are presented to a court. Now, getting those facts can be difficult, but if the right facts are presented to the court, I think there's a lot of judges who'll be very, very willing to write opinions that support designating votes or subordinating claims. And I think that, I would certainly like to see more academic literature that within the existing bankruptcy code supported remedies. You're not going to find it in 105, okay? But will support remedies that have a realistic chance of being applied. And then, of course, it's going to depend on the lawyers being able to present the facts in such a way, a compelling story about why a remedy is appropriate in that case. Okay. There's no question that there can be bad conduct by creditors. When a competitor sets out to destroy the debtor because it's a competitor, when its only goal is a 363 acquisition or through a plan, and it's not really pursuing a creditor interest, it's claims that it acquired in the case. Those may be situations where within existing law, maybe with a little stretch, you could get to the point of a remedy. I think, from my standpoint, figure out the disclosure, because if you don't have the facts in front of you, you're not going to be able to get a remedy. I think, and this was touched on earlier today, I think, for a future conference, Ted, one of the areas that's bubbling around, I see this issue raised regularly is about third-party releases. Every plan I'm seeing has got everybody under the sun that they're proposing to release. The U.S. trustee, in most cases, because they have a consensual plan, none of the parties other than the U.S. trustee wants to object to it. Okay, that's a problem. Okay. Yes, Judge Bernstein on my court has written a bunch of opinions where he's pushed back on it and refused to approve the releases. But I'm reading in 363 bankruptcy, I see all over the country this issue of third-party releases is coming to the fore. It's part of that special deal that, that's involved. Everybody, and yes, the cases differ about exculpation, stuff that happens during the case versus the third-party releases, typically the pre-petition
If you
conduct.
can't get it here, you go to Canada and then bring it back.
Well, I did that, yes, twice. Metcalfe and Mansfield and Sino-Forest. But, the court in Canada had jurisdiction to approve those releases, and it did it thoughtfully. And the issue was, could I approve third-party releases when I might not be able to do it in a plenary action here? Based on comity, I said yes. Okay. But even, in connection with an upcoming conference, a very excellent judge in Canada he thinks that their court's gone too far in approving releases. Okay. So I think that's going to be one of the battlegrounds. And I think it goes in part, Steve and Oscar, to what you talked about what are these benefits that management or creditors are insisting on. Yeah. I'll stop.
So I'll I guess, segue a little bit, because I want to open it up to we're getting towards the end of the day, but I want to let people get in a little bit more. But just to sort of take the themes together, and it was interesting, because we didn't really intend this to be all about Ted and Adam's goofy idea. But that's the nice thing about a goofy idea. It sort of crystallizes the attention and gets people to take it on, and I'm happy for that. One of the things that has come out throughout the day and came out particularly last night is that there is no easy, straightforward law fix to any of the things that we're talking about, right? It came out clearly last night. It came out even more clearly today that fiduciary duties, while important in the way they get people to think, do very little work once you're in an insolvency situation where you've got multiple creditor constituencies and where the business choices are going to have differential effects. And so on one level, it's nice to say be honest, but that doesn't help you. Bankruptcy, on the other hand, is equipped, at least to the extent that you have a full-on plan process, to structure a negotiation where those things get fleshed out and to put some entitlements in the background to structure that negotiation. But increasingly we see that doesn't ever happen because everything gets done by 363 sale. And on the other hand, that's not necessarily bad because 363 sales have a lot of good things about them. The thing that ends up being absolutely crucial, particularly in the early cases, but also in the late cases, is that we've got judges, right, who are pretty good, I'll go further, really good at smelling when there's an abuse happening somewhere in the process. And the thing that I'm really kind of curious about going forward, and part of the Adam piece was aimed at the piece with Adam was aimed at this, is what is the toolkit that you need to give a judge in order to empower them to catch the abuses, and this goes to your disclosure point, to catch the abuses where they exist, and the tools to deal with them, or at least push the parties where they're seen, and how do you get there? And I think disclosure is part of it. I think thinking about some of the toolkit pieces that are floating around are there. One thing, though, that I think is important to think about is how the Rule 2019 conversation that Judge Gerber did with his letter, where that came from, right? It started with Nortel, which is a bankruptcy judge basically saying, no, you have to disclose, and the market's going nuts,
Well, man.
right? So there is a certain ability of the bankruptcy, maybe this won't happen with legislation, it probably won't happen with legislation, but to the extent that there is an ability of bankruptcy judges to force the issue onto the table with opinions, that's not necessary, and for parties to do the same thing by getting it in front of bankruptcy judges, that's possibly a good thing.
Can I just say one thing?
Absolutely.
I mean, I don't think 363 brushes everything under the rug. I think 363 is a wonderful tool. You often have in bankruptcy the melting ice cube. A company, GM, the car companies, they had to be sold overnight. And so what you have is you have the asset changed from, this ongoing business to a pot of cash. Nortel, pot of cash, and it was, as people said, it was a lot of cash because people agreed to defer the issues. And then once you have the pot of cash, it's just a different form of currency, then everything gets brought out in a process that is very adversarial. The only other comment I'd make is, I agree totally. I don't think you can block claim trading, maybe because I represent a lot of hedge funds. I certainly have that view. A lot of them are very aggressive. That's not the end of the world. They pay more to buy claims and help get the guy out who wants to get out and, who can't stay in this, because they're willing to put a lot of money behind a thesis that they have about this was a fraudulent transfer, that wasn't a fraudulent transfer. The fact that Aurelius, right or wrong, was willing to had as strong a view as it had in Tribune that was a fraudulent transfer, got a lot of creditors paid a lot of money on the dollar, and, that litigation is going on today, 10 years later still, 8 years later. And, I don't think that's a bad world where you have a fund that's willing to spend much more money to get creditors who want to get out because it has a strong theory and conviction about a litigation claim.
If I could comment, one of the possible adverse consequences of Ted's mark-to-market
I
thesis.
put it out there.
Of Ted's mark-to-market thesis is that those who are interested in acquisition to block or acquisition for control are interested in being able to vote all the dollars acquired by the purchase. And if it's mark-to-market, there is a disincentive to enter the market. So that's a market-sensitive reason, unrelated to whether it's a good proposal for other reasons, that it might not be a good proposal. And I'm not being critical. I'm just commenting on what Phil said. I also think that apropos of Jay's comments this morning about disregarding corporate form in the interests of recognizing a global enterprise that trades under the same brand. Those like Aurelius that invest in this market do so on the basis of incredibly detailed diligence of the corporate org chart. And what they're looking for are those boxes that represent pole positions within the capital structure. I'm not saying that that's a good thing or a bad thing. I'm just saying that's what happens. And it would be contrary to the objectives of those who are seeking to exploit potentially strategic positions in the capital structure to put them in a position where it doesn't matter.
John?
Okay, so much discussed, really interesting presentations, David. The disclosure point is what links the first and second comment I think you made. Oh, sorry. First and second comment you made is linked by disclosure, which is if fiduciary duty is not going to do it, and we want to have the court process, which we think does look pretty well, is more transparent, right? Is there has to be the information before the judges so they can adjudicate the claims properly. And I don't know if we force that through expanded disclosure obligations or what, but we got to get it out there or else this doesn't work. Same with the market. The more information that flows, the more perfectly the markets work. And if we don't have what we consider to be the relevant information out there, then it's not going to work. Jay, I'm attracted, obviously, to your position of substantive consolidation. Wear the badge with pride of substantive consolidation. What's fascinating about Nortel is the judge. Well, one of the things I found fascinating about Nortel is that who was it? Was it Gross? Carey, the Delaware judge, was so anxious not to be accused of the love that dare not speak at stay. It's like, this is not substantive consolidation. What we're going to do is consolidate the claims and treat them all together. That's not subcon, no way. And the Canadian judge doesn't have the baggage we have here. It's like, well, what's so bad about subsume consolidation? It's put it together. It seems like we don't have to do it here, but it seems okay to me.
Read Owen's corner.
Yeah. No, so there's I wrote a piece that you may want to look at about, I think I wrote for TED, one of your previous conferences, on the normative framework for choice of law, basically calling the bluff on all the sophisticated actors who say like, oh, look, well, we relied on the corporate form, and so if you have a universal system, we'll be totally like shocked and surprised. Like, really? No. So no, here's what you do. You want to make an argument, so the presumption is going to be we're going to consolidate. You want to make an argument that you relied on it? Absolutely. If you've relied to your detriment, like you're a small guy, you didn't know it was incorporated abroad, then totally you get the application of your local law. Otherwise, we presume sophistication that you can tolerate an international thing, and I think the same reason could extend your model as well. I think that there's, to get to Marty's point about do we change the law? No, the law's never going to change. Right after they take up the ABI Commission's recommendations, but can we talk about things, ventilate issues, and get us paying attention to them? And I think that's what David, others have brought up too, which is, should we be a little more comfortable with 1126E, right? Then we have a baseline, so it's got unfortunate labels, right? Bad faith and stuff that in our judicial culture we're loath to tarnish people with that epithet. But maybe we call it something else, like market disruption, vote dilution, or something like that. We might be more willing to do it. And I think if we think this is a problem, then we can use existing tools to redress it. I think that one of the hardest things in bankruptcy is this bad faith. I mean, this is true across many domains of law as well, I'm sure. I jokingly called it the pornography question, like when, how do you classify it as wrong or off the edge as opposed to just racy, right? And so what do we consider aggressive guys who do a lot of due diligence, who bring liquidity to the market as just like good self-interested behavior versus it's going too far, it's bad faith, we have to disqualify the votes. And it's really hard. I've tried, and I don't know if I'll ever finish kind of paper to give content to it, because it might just have to throw up your hands like pornography and say, we know it when we see it. Or you might try to look for external third-party things. So you see with Fisker, right? Fisker, when they marked down the claim, I felt comfortable with that.
Freelance Star, because they explain what they're doing better and they do the same thing.
So when they cap the credit bid of the secured creditor not at the nominal amount of the debt that they purchased, but capped it down to the acquisition price of what they paid for the claim. And there's doctrinal hook, you can do that for cause, right? 363, whatever it is, K says you can do it for cause. For me, what was convincing in Fisker for this being justified is they said it's going to chill the market. The credit bid is going to not flush people out there who can bid, and this gets to what you guys are doing in your project too. If you flush out the market and bring more people in, you might create more value for everyone. And so I can get my head upon that as a doctrinal hook. Say, here, it's not bad faith, you're not evil, it's just we want to have a good market. You're market chilling. And that might be something we could feel comfortable with and get our heads around.
One other thing. Of course, you all know that academics are always struggling to somehow make it look as if what we do matters, right? So as a contribution to that project, one thing that strikes me is that there's a group of the tax people who have what is called the Shelf Project, right? And what they do is propose various amendments to the tax code that are put on the shelf. It's a shelf that wasn't looked at in this last round of tax reform, but it's there. And so it occurs to me, yes, it's unlikely that we're going to get a statutory solution to any of this soon, but there does tend to be a tendency when all hell breaks loose for Congress to take another look at some of these issues. So it seems to me there might be some use for our proposing some things that we could put on the shelf until Congress is stirred by some catastrophe to a big shelf, big wide shelf, to take a look at these questions.
We want those ideas to be fully vetted, which is
Indeed.
I mean, so picking up on John's point, the idea behind mark-to-market is that it's not a blame game. It's how are we going to get this right? One thing I just wanted to sort of point out, that if you, on the mark-to basis, right, where you discount the voting rights to, what that does is it makes it relatively more expensive to buy a blocking position, but relatively only a little bit more expensive to buy an accepting position. Which is to say, if you actually want to control the class, the incremental difference in cost is relatively small.
It is going to have the effect, though, that Judge Peck cited, which is it is going to say to me, I don't I'm not going to get as much from buying the position, so I'll pay less for it, so creditors get less. I will say, look, this may just be my own reaction from basically thinking it's a system that works. Designating a vote, saying you're a creditor, but we're not going to let you vote, and maybe I'm thinking of like confusing voting in the bankruptcy sense and voting when it comes to elections, but there is something almost un-American about it, and it to me, you've got to be a really, really, really bad actor before your vote gets designated. Similarly, and maybe again, this is a prejudice I come to and representing a lot of secured creditors, my going-in view is that bankruptcy law isn't supposed to alter state law rights except in unusual circumstances. And the notion of telling a secured creditor you can't credit bid when you could under state law, again, on some level strikes me as messing with a state law property system that has worked for a long time and is un-American. I'm giving my bias of who I tend to represent.
The contrary thing, so, Butner says, unless there's a contrary federal bankruptcy purpose, and if flushing out more money for the estate, I'm not taking away the secured creditor's lien, he still gets all the proceeds. If I get more value for something, I think that's a pretty good contrary interest.
So it's 4:30.
Although, you're increasing the cost ex ante. I mean,
That's right.
so whether
There's
you're
no,
really getting more
look,
value is
there's never, free,
debatable.
I will give you, there's no free lunch, okay? And Ted's proposal is less radical than designating the vote, right? He's just diluting the vote, right? And you're right, there's gonna be ex ante cost anything. So it just gets to the empirical point that David raises, which is how big a problem is it that we think, how big a problem is it? And are we willing to incur those costs to solve the problem, or is this an overexpensive elephant gun?
And on the credit bidding point, I'm not saying you lose your right to credit bid your collateral. I'm saying when there is collateral, when there is stuff being sold that includes your collateral and other things, you have to allocate it.
That I agree.
Like the going concern,
That's all
like the
I'm
going
saying.
concern surplus
That's
or
all I'm
whatever.
saying, actually. Well, then, is the going concern surplus part of the collateral? That's a way too controversial.
You mean the
point to take on
property
right
created,
this second.
the property created by the government through its institutional support of a bankruptcy system?
Okay. All right, on that note, I just want to say, I've had such a good day. This has been a treat for me. Thank you for indulging me. I hope you've all had as much fun as I have, and I'm sure I speak on behalf of I think the journal kids who are still here. Thank you all for the work that you have done and will do. I'm really excited about what this volume is going to turn into. Just because you didn't turn in a draft before the symposium does not mean that you can't write one for the ultimate volume. Have a super nice evening, weekend, President's Day, whatever it's, St. Patrick's Day, whatever's on the way. Thank you all.
And let me just add to that, that once again, we've been indulging him, Ted does do extraordinary conferences, and it's very gracious of you to put this together, and for the students and everyone here at Brooklyn Law School, it's been a pleasure to come and attend.
Thank you.